Hello everyone. Welcome to the session on Personal Laws, Part 4, Women and Succession. The objectives of this lesson are: firstly, historical view of the succession rights of women. Secondly, to analyze the modernization of succession rights of a woman under Hindu, Muslim, Christian and Parsi personal law. Lastly, to highlight the need for gender equality in property rights. Let us now start this session. With the progress of civilization and recognition of rights in property, succession was one of the important aspects which humans had to address. Succession deals with how the property of a deceased person devolves on his heirs. As with all other issues, succession was also decided against women, and women were generally disadvantaged when it came to equality in succession. Complicating this further, women's succession rights were clouded by the complex weave of personal laws, social norms, and customs in pre-independence India. Women's right to succession depends on her religion, her marital status, part of the country she belongs, the tribe she belongs, and so on. Further, it also depends on her status in her family, whether the woman is a daughter, mother, wife, married, unmarried, or widow. It also depends on the kind of property at issue, that is, self-acquired or ancestral property, land, or dwelling house. The denial of equality in succession to women increased the dependence of women on men. Due to various legislative attempts at providing succession rights to women in independent India, even if they were mostly incremental, the customary anomalies were attempted to be swept away. Under the Mitakshara school, which was followed across most of India, Hindu women were not co-partners and hence generally stood excluded from succession. Muslim women, though they were not treated equal to men in succession, were better placed than their Hindu sisters as they had determined shares in succession. Succession may be by testamentary succession or intestate succession. The religion of the deceased determines the succession to his estate. Succession among Hindus is governed by the Hindu Succession Act 1956. Christians and Parsis are governed by the Indian Succession Act 1925, and Muslims are governed by Sharia. Succession to the property of persons marrying under the Special Marriage Act 1954, as also succession to the property of the issue of a marriage thereunder, would be governed by the Indian Succession Act 1925, which also recognizes the principles of intestate succession applicable to Christians. Let us start with Hindu women and succession. Originally, Hindu women had no place in the scheme of inheritance and were entitled to get only expenses of their food, clothing, education, and marriage out of the co-partnership property. The Shastric Hindu law conferred only two types of property to women: Stridhana and women's estate. Apart from these two, women had no other property rights. She has absolute rights only on her Stridhana. Women holding women's estate enjoyed limited rights during her lifetime and she could not alienate the same. The Hindu Succession Act 1956 overhauled this antiquated system and provided succession rights to women. The limited estate has been abolished with effect from 17th June 1956 by Section 14 of the Act of 1956. Any property held by her under limited estate prior to the commencement of the Act converted into her absolute property. The Act of 1956 abolished the distinction between Stridhana and Hindu women's estate and makes the Hindu woman full owner of all the property possessed by her. She is now free to dispose of the property by sale, gift, or will Thus, it is to be noted that the Act of 1956 has brought about a sea change in Hindu women's right to succession. While a Hindu woman's right to pass on her property to her heirs and her right to succeed to others' property is governed by the Act of 1956, her right to make a will or inherit through a will is governed by the Indian Succession Act 1925. Under the Act of 1956, the property of a female dying intestate devolves firstly upon the son and daughter and also the husband, secondly upon the heirs of the husband, thirdly upon the mother and father, and fourthly upon the heirs of father, and lastly upon the heirs of the mother. The rules are specified under section 16. Though Hindu women's estate has been abolished by section 14, the scheme of succession to the property of a deceased female depends upon the source from which she had secured the property. If the female dies issueless, any property inherited by her from her parents devolves upon the heirs of the father, that is, as if the property of the father. Any property inherited by her from her husband or from her father-in-law devolves upon the heirs of the husband, that is, as if it was the property of the husband. If she has children, the distinction between the sources of the property is not material. Thus, we see that the source of property, which is immaterial in the case of males, is of prime importance in case of females. If she dies leaving behind no relation, the government takes her property, just as in case of a Hindu male. Thus, we see that the Act of 1956 has brought about considerable changes in the succession rules of females' property. The Act has brought about substantial changes not only in the rules of succession to her property, but also in her rights to succeed to the property of her parents, whether self-acquired or ancestral property. The original Act of 1956 did not give co-partnership interest to the daughter on par with the sons. From the commencement of the Hindu Succession Amendment Act 2005, the daughter becomes a co-partner in the same manner as the son. Any property acquired by her through such co-partnership interest shall be regarded as her absolute property. The Supreme Court in Prakash and others versus Fulavati and others in 2015 held that the daughter is allotted such equal share only if both the father and the daughter are alive on the date of commencement of the Amendment Act of 2005. The effect is that no distributions of such properties of persons who passed away prior to the Amendment Act 2005 can be reopened or questioned by daughters. Prior to the Amendment Act of 2005, a female heir cannot seek partition of the dwelling house left by the deceased until the male heirs divide their shares. But now, the daughter has a right to claim partition in the joint family properties as well as the right to claim the right of partition in the dwelling house of the family, and she also has a right to claim partition during the lifetime of her father. However, a daughter still has limited rights to ancestral property. A will can deny a daughter all rights to parental property. If a Hindu male doesn't make a will covering his share of the co-partnership property, upon his death, his share will devolve according to Section 8 of the Act of 1956. Upon the partition of a joint family property between her husband and his sons, wife is entitled to a share equal to as any other person. Upon death of her husband, she is given an equal share along with her children and his mother. She is a Class 1 heir who inherits on par with children and mother of the deceased. Remarriage of a widow of lineal descendants is now not a bar to inheritance after the Amendment Act of 2005. Even an unchaste widow may now inherit. Now, the female member can also become a karta and can carry all duties and responsibilities in same manner like men. Class 1 heirs have been broadened, and now the heirs of predeceased daughters also got right to inherit the ancestral property. Thus, it may be noted that a Hindu woman now inherits property as a widow, daughter, mother, widowed daughter-in-law under the class 1 category, and also as a sister, niece, grandmother, brother's widow, or even as an aunt falling under class 2 heirs. She is granted with the much awaited equality rights under the Act of 1956. Let us now see Muslim women and succession. In India, the Muslim woman is governed by the Muslim Personal Law Sharia Application Act 1937. Prior to this act, Muslims were governed by the local customs, laws and practices which were contrary to the Sharia. The customary laws were majorly discriminatory and highly unjust. But the Sharia gave equal rights of inheritance to males and females. Muslim law does not make any distinction between self-acquired property and ancestral property, nor between real and personal property. There is no concept of widow's limited estate. The joint family system or the joint property like that under Hindu law is unknown to the Muslim law. The doctrine of survivorship followed in Hindu law is not known to Mohammedan law. The share of each Muslim heir is definite and known before actual partition. Rights of inheritance arise only on the death of a certain person. Under Hindu law, a male member gets a right in the coparcenary property as soon as he is conceived, and all the members are jointly owners of the whole of the property. Under Mohammedan law, the right of an heir comes into existence on the death of the ancestor. Muslim law permits disposition inter vivos and testamentary disposition. While the former is unfettered as to quantum, the latter is limited to 1/3 of the net estate. Mohammedan law allows a man to give away the whole of his property during his lifetime, but only 1/3 of it can be bequeathed by will. A Muslim woman has the same right to make gift as a man, and marriage does not entail any disability. Any Muslim woman of sound mind and who is a major may dispose of her property by will. A will by Pardanashin woman is valid if the propounder of the will satisfies the court that the transaction was explained to the lady and that she knew what she was doing. A will may be made in favor of a Muslim woman, married or unmarried. A Muslim woman also be appointed as an executor to execute the last wishes of the legator. The estate of the deceased Muslim would be administered according to Indian Succession Act 1925, and Islamic law would be applicable on those points where it is not in conflict with the Act or where the Act itself has not provided for it. According to the Act of 1925, the estate of the deceased Muslim is to be applied successively in payment of funeral expenses, expenses of obtaining probate and letters of administration from the court, wages for personal services to the deceased before his death, debts, legacies not exceeding 1/3 of what remains after payments of these items. What is left after deducting these items from the property left by the deceased Muslim is his or her heritable property, and it is this property that devolves on the heirs and is distributed according to the law of the sect. Among the Sunnis, the heritable property first goes to the sharers or the Quranic heirs who are 12 in number. If after the distribution to the first class of heirs, the estate is exhausted, the rest of the classes would get nothing, but if something remains, then the residuaries, that is, the agnatic heirs or near male agnates, would come into picture, and the second step would be taken to allot their shares. In the absence of these two classes of heirs, the estate would devolve on distant kindred or blood relations. The distant kindred are not entitled to succeed so long as there is any heir belonging to the class of sharers or residuaries. For example, if a Muslim female dies leaving a husband and distant kindred, the husband as sharer will take the half share and the other half share will go to the distant kindred. The husband or wife would take their own shares as long as there are any other heirs. Males and females have equal rights of inheritance. Upon the death of a Muslim, if his heirs include also the females, then male and female heirs inherit the properties simultaneously. Males have no preferential rights of inheritance over the females, but normally the share of a male is double that of the female. While a female heir gets an additional money or property as her meher and maintenance from her husband, her male counterpart gets none of the two benefits. The male heir is further liable for the maintenance of his children, whereas the female heir may have this liability only in an extraordinary case. A widow is entitled to 1/8 share of her husband's property when there are children and 1/4 share when there are none. A daughter gets half of whatever share her brother gets. In case she has no brothers, she is entitled to a share of half the property. A mother will get 1/3 share of her son's property when there are no children and 1/6 when there are children. The maternal grandmother will get 1/6 the share of the total property only if there is no mother or grandfather. The paternal grandmother gets a share only if there is no father or grandfather. Thus, we see that a Muslim woman is entitled to inherit property as a daughter, widow, grandmother, mother, or son's daughter. Thus, it is evident that the succession rights of Muslim women were progressive when compared to other aspects of Muslim personal law. Let us now discuss on Christian women and succession. Sections 31 to 48 of the Indian Succession Act 1925 provide rules of succession for Christians. Both Christian men and women have identical right of succession to ancestral property. If a man or a woman dies intestate, the property will devolve such that the spouse gets a 1/3 share and children get a 2/3 share. If the deceased has no children, the property will be divided such that the spouse will get half a share and the kindred or relatives will get half a share. If the deceased has left a widow but no lineal descendants or collaterals, she takes the entire estate. It is to be noted that in presence of widow, the children and descendants will take 2/3 share. However, if the property is not worth more than 5,000 rupees, the whole amount will go to the widow. If the property is worth more than 5,000 rupees, the excess devolves according to the rules laid down under the Act of 1925. A widow may be excluded from inheritance by a valid contract made before her marriage. Thus, we see that the Indian Christian widow's right is not an exclusive right and gets diminished as the other heirs step in. One deviation from the common rule is that the widow of the predeceased son gets no share, but the children would be entitled to equal shares. When there are no lineal descendants, after deducting the share of the widow, that is 1/2 the share, the remaining share goes to the father. If the father is dead, the mother of the deceased takes the whole of the property after deducting widow's half share when there are no brothers and sisters or their children. Where the intestate has left no widow or kindred, the estate will go to the government. A husband of the deceased has the same rights which the widow has in respect of the husband's property if he dies intestate. The rules of distribution of the intestate's property after deducting the widow's share amongst his lineal descendants are laid down under sections 37 to 40 of the Act. A Christian can bequeath his or her estate by will. Let us now discuss on Parsi women and succession. Sections 50 to 56 of the Indian Succession Act 1925 provide special rules for Parsis dying intestate. On the death of a spouse, the entire estate is divided equally among the widow or widower, whoever survives the deceased, and the children. If the deceased is spouseless, the estate is divided equally among the children. If the deceased is survived by parents, each parent will get a share equal to half a share of each child. If the relative of the intestate remarries during the lifetime of the intestate, then she shall not be entitled to receive any share. Section 50 does not make any distinction between those who are actually born in the lifetime of the person and the child in womb. If the predeceased son of the intestate leaves a widow and children, the share of each predeceased son in the intestate's estate shall be divided equally among the children and the widow. If the predeceased child was a daughter, her share shall be divided equally among her children. Thus, we see that the Parsi succession law is gender just. In summary, every Parsi woman as a widow, daughter or a mother receives her due share. We will now conclude with a few words. Position in law and the ground reality are usually poles apart, especially when it comes to women. One of the major reasons for this is the ignorance of law by women generally. Hence, dissemination of law more widely among women is the need of the hour. It may also be noted that, irrespective of the legal position, due to societal pressure, women are generally forced to give up their share of their parents' property in favor of their brothers for various reasons. Empowerment of women remains elusive until they are conferred with succession rights on par with men. Acknowledging this equation, the legislature has been amending succession laws, gradually granting equal rights to women and removing the legal disabilities that hampered their economic independence. The glitches of previous acts were removed by the subsequent acts that came into force. But since the whole exercise is being conducted in a patriarchal paradigm, many mismatches and rough ends remain. The numerous central and state laws have complicated the matters of succession, and there is a pressing need for a simplified and uniform body of law governing Indian women's right to succession without any kind of gender bias. Hope you have enjoyed the session. Thank you. Have a great day.